Please, Your Lordships.
Morning.
As the first advocate to speak, it's my happy duty to say on behalf of all of us, first of all, many happy returns, but also to acknowledge, obviously, the enormous contribution Your Lordship has made generally. I believe Professor Douglas may say a few words.
It's very
I should also say, by way of preliminaries, I'm not only joined by my junior Mr. Webb today, I'm also joined by Advocate Eleanor Moran, who is the Jersey advocate who represented Tepe and the two courts below, being the only Jersey qualified lawyer amongst us, although I appreciate some of you have got experience of it both on the board and in the Court of Appeal. It's in case any issues arose. In outline, my lords, I intend, subject to your lordships, to address you in 7 broad areas which I hope flow into one another, that covers a wide range of topics in the time available. Part 1 will really be a brief introductory remarks, summarising the differences between the two parties as I understand them, at least. Secondly, to examine what I believed, anyway until yesterday, were 3 fairly uncontroversial propositions, and then look at how Botash's case fits in with those propositions in general terms. Thirdly, to look at the authorities for those propositions, and they will be authorities familiar to at least 2 of your lordships because they're Belhaj and the Gekameen and Hemisphere cases. Then, fourthly, to look at the specific provisions of the Act itself. At that stage, I will then draw to a close on our primary case. The 5th area will be to turn to look at the alternative case, which is in effect as found by the Court of Appeal, starting with the factors that my learned friend relies on to establish his concept of interest and control, and then to look really on mainly at the special legal regime that he relies upon. Sixthly, I will look at the authorities that my learned friend relies on, particularly the Christina and the other requisition cases, and then there's some miscellaneous points at the end. So I turn to the first part, which is a general introduction, and as will be apparent from Tepe's written case, we take a very different approach to the construction of the State Immunity Act than Botash, at least as explained orally yesterday. Our case is, I would submit, a conventional one, which is that it creates a clear and comprehensive code to deal with state immunity in UK and Jersey law. It falls to be construed in the normal way as an English Jersey statute. That is subject, of course, that because of the subject matter of the Act, it falls to be construed against the background of international law. But there is no provision of customary international law that's been asserted or proved in the present case that is actually relevant to the task before your lordships. Because the central question in the present case is over what the meaning of property is within an act that's dealing with enforcement of property in the jurisdiction of, in this case, the Bailiwick of Jersey. And that's something which, as my learned friend accepts, the only touchstone can be the municipal law. I will examine my learned friend's case in a little bit more detail in a moment. But as I understand the approach that they are taking, it is to say that in an enforcement case, you can effectively ignore any notions of property rights or interests, or indeed who is being sued, whether they're a separate entity or indeed even a private company. Because in his answer to my Lord Lord Mance yesterday, his test effectively came to this. And my Lord puts him, effectively, you are saying we can forget property, and anything that is being used for a sovereign purpose is immune. And Professor Douglas said that should be the principle at the end of the day, and that's page 23, lines 7 to 11. It's not the only place in the transcript where my learned friend put the case as widely as that. And as I understand his...
Have we been vouchsafed with a transcript? If there is one...
I do not know, but we have copies
not.
if you're
I mean, what would be helpful would be not only to have it in hard copy, but to have it electronically.
Certainly.
If you could send it to the registry. Thanks, but let's have it in hard copy now if you're going to refer to it.
I'm not anticipating going, I just put it, the references for your lordships.
Yeah, no, I mean, if... Right. So,
But my learned friend's proposition, in essence, is to ask the question, is the property in question either being used for a sovereign purpose or may be used, I think is his case, for a sovereign purpose in the future? And if the answer to that question is yes, his submission is that any property becomes state property for the purposes of the Act. And I'll come on to examine what the consequences of that are in my next part. But we take a very, very different view to that approach to statutory construction and base ourselves really on what the Act says. And not only what it says, but as we believe it's been interpreted by the courts in this country. In the primary case can be put quite simply that property for the purposes of section 13(2)(b) means a proprietary right or interest in or over property which is recognised and enforceable in private law. We accept that that encompasses all types of property and it will cover the full range of private law interests. We've summarised that at paragraphs 88 to 90 of our written case, which your lordships have on page 38. I won't read it again, but in essence, it's a combination of the test as explained by Mr. Justice Aikins. Sorry, my lord, it's page 38 of our written case. Paragraphs 88 to 90. It's the combination of the test enunciated by Mr. Justice Aikins in the light of Allcombe. That's paragraph 89, but also, of course, acknowledging the case I'll turn to in a moment, which is Belhadge.
So, I mean, you do accept that it includes an equitable interest. You're not losing legal in its technical sense.
Yes. Yes. And so when I use legal interest, I'm using it in that context that I've explained. The alternative case is essentially the one that was found by the Jersey Court of Appeal, namely that even if property of a state is broadened to include concepts of non-proprietary interest, control, or possession, where there's no legal proprietary right or interest in the sense described, then on the facts, Botaş cannot establish that the Republic has a claim to sovereign immunity.
If there has to be a nexus between the judgment debtor and the property, and I think it's common ground that there has to be some kind of nexus, as opposed to a nexus between the judgment debtor and the owner of the property, is there any interest other than a proprietary interest in the strict sense of that term which would qualify?
No, and the reason, in fact, there are lots of reasons, but one of them is that Section 13 is concerned with enforcement, and it's enforcement against property. And if one just forgets about the facts of the current case, if this was a claim against the state directly, the only reason you would be seeking to enforce against the property of the state is because they have a private law interest in that property which has a value. That's the purpose of the section. So the threshold question is always, is it their property in that sense?
Would it, apart from the immunity,
apart from then
be property which could be taken in execution?
Exactly, man. And that, at the end of the day, it's a difficult case because it comes down to saying property in an act dealing with property in the English jurisdiction or the Jersey jurisdiction means property. We've had a lot of authorities to say it doesn't mean property. In relation to both of our cases, and we don't really mind which because they lead to the same conclusion, we believe the primary case is the correct one, we suggest the Act provides a clear and sensible structure by which one goes through the processes of determining whether or not an asset or the state is entitled to claim immunity, and I'll come to those in a moment. And we take a very different view, it has to be said, to Botaş as to the intention of Parliament in passing the Act in order to implement a version of the restrictive theory of state immunity. My learned friend said yesterday, and again I just give your lordships the reference in the transcript, it's page 20, lines 3 to 6, that the policy behind the restrictive rule that Parliament was intending to enact is not to protect state property as state property, it's to protect state property as state property being used for a sovereign purpose. In our submission, the clear intent of Parliament was to ensure that where a state enters into the commercial arena and loses its cloak as a sovereign, becomes a trader, it takes the consequences of that. So it's the opposite of the way that my learned friend put it. I'll come back to that in a moment.
So the starting point is that the property, there have to be concurrent subsisting interests in the property, one held by the judgment debtor so as to enable it to be used in principle as a basis of execution of the debt, of judgment debt. And at the same time, some other proprietary interest held by the state so as to bring into play the possibility of state immunity.
And I don't accept, for example, my learned friend's suggestion that Section 14.2 doesn't apply in an enforcement case. It clearly has been interpreted to apply. Taurus is an example. I believe my Lord Justice Briggs was involved in that case and in the bundles. But in simple terms, that in its own, if one looks at Lord Gough in Kuwait, he interprets...
If one looks at...
Lord Gough's opinion in the Kuwait Airways case, yes. He interprets Section 14.2a as being importing the test of whether or not the act is a commercial act or a sovereign act. So one could have a position, for example, where a separate entity may have something, say it has some proprietary software that the state owns and has a real interest in, which is incorporated into something they're manufacturing, where in relation to that act, they are acting in sovereign authority because it's something that's related to national security. But what that would then do is give rise to a claim by the separate entity for sovereign immunity, not the state. But in principle, my lord, you're right, that you could see if you had mixed title, there was a legal and equitable split, then, of course, you'd be then in Section 32A. But that isn't this case. And I'll come on to explain how I developed that But to develop the answer that I've just given to my Lord Reid a little bit further, the thrust of our case is that when one looks at the Act and one accepts that the principle that underlies it is to make sure that where the state chooses to enter into the commercial arena, it takes the consequences of being a private trader. The paradigm example of that is if the state sets up deliberately a corporate entity to engage in commercial activities. And that's why Section 14 is there, because it's making it very clear indeed that if the state chooses to do that, then the consequence is they do lose their immunity, save in very exceptional circumstances. And that is, in effect, the Gekomedian Hemisphere case.
What are the exceptional circumstances?
Sorry,
what are the exceptional circumstances?
Exceptional circumstances would be Section 14.2.
Yes.
So, if the state itself has a proprietary interest in the way I've just discussed. And, of course, there is still the overarching sovereign immunity, which I will come to, which is because it is a personal immunity, you cannot get orders that require the state to do something. So it doesn't matter what their interest is. Under Section 13.2a of the Act, there is an express prohibition, if one wants to look at it. It hasn't been mentioned much, but your lordships have it. Helpful, I went to the right bundle rather than in Volume 1 of the Authorities bundle. And it's at page 10. Section 13.2a, which is not subject to any exceptions, the relief shall not be given against the state by way of an injunction or order for specific performance or for the recovery of land or other property. So there is an express prohibition, if one had a case, for example, and I'll develop this in more detail, of mere possession with no proprietary interest whatsoever. If you were seeking in the proceedings to recover possession from the state, you could not get the order. because of section 13.2a.
But you could get a declaration.
Declaration. And that's why, for all the interesting authorities that my learned friend has cited, it just doesn't come into section 13.2b, because they're all section 13.2a cases. Turn now to part 2, which is the general propositions, and I apologise, because I had thought these were very simple propositions, probably not even quite first-year university propositions. But in the light of my learned friend's submissions yesterday, I thought it might be helpful in case I was missing something. But the first principle of the proposition is the court will not entertain proceedings which may adversely affect. First proposition is that obviously state immunity is personal, and that's Bellhatch. And the exceptions in the Immunity Act apply to subject matter, but they're very wide, and I'll come back to that. That leads to the second proposition, which is because the sovereign immunity is personal, there are two ways which, for present purposes, it might be engaged. The first is the principle that my learned friend has principally been focusing on, which is the court will not entertain proceedings which may adversely affect property interests, and clearly there's a debate about what that means.
That's the indirect impleader principle, right?
And the second is that the state cannot be personally impleaded in the sense we've just discussed, and you cannot make them subject to a mandatory or a order or a restraining order.
What's the position if you have a separate entity carrying out sovereign acts? Let's suppose one's talking about independent security contractors in Iraq, for instance, an example that was cited in an analogous context yesterday. Now, if you wanted to sue them in respect of a sovereign act, they would not be a state. But if the act was categorized as a sovereign act, and on the face of it, killing people in Iraq is a sovereign act,
Section 14.2K.
Section 14, but does that operate by requiring you to treat the separate entity for that purpose as the state? Or does it operate to extend the immunity to entities that are not states?
Strictly, my lord, it operates to extend the immunity for that by treating the separate entity as, in that capacity, acting as a state. So although the sovereign immunity, the separate entity is claiming the immunity.
It's the immunity of the state.
It's the immunity of the state. But the importance of that distinction runs right the way through in my submission through this case. And again, summarising our submissions in unduly simplistic terms, the Act protects a state where it has possessional control over the asset, irrespective of whether it has a proprietary interest, by Section 13.2a. But that's a protection against the proceedings being brought against the state. It has nothing to do with their property interest. It's based on the principle you cannot implead the sovereign.
Based on the principle that
You cannot implead the sovereign directly. And an obvious example would be, for example, a creditor of a third party could not get an order against the state for delivery up of possession of property that's in the possession of the state that belongs to the third party. But if the nature of the proceedings were, for example, for a charge over that property, which did not affect the possession, then there's no question of state immunity that arises. And just so we can put it to bed, if one could just please take up the record in volume 1, so we can look at the order that's actually made in the present case. Tab 12, page 253. Tab 12, 253. This is the order that we are concerned with, and one sees from paragraph 2.21 that the order is that it's to pay a sum of nearly 97 million plus interest. 2.2, the array en applies to those sums until they're paid. 3 gives power to the Viscount to realise the shares by such means as the Viscount may decide, either by private sale or public auction, subject to getting a valuation in 4. And then there are obligations in 7 and 8 on Tippich and Bill, the Jersey companies, to cooperate with the Viscount. So there is nothing in the order that affects the Republic of Turkey. There's no requirement on the Republic of Turkey to do anything. There's no claim for an order up for possession. There's no claim for them to restrain from doing anything. So we're not in the territory that my learned friend would like us to be in, based on his submissions, of where there is a claim against the state and the courts have declined jurisdiction, irrespective of property interests, simply because there's a claim against the state, because there is no such claim. There is no such proceeding. And it follows in my submission from that short analysis that the pre-Act cases on which my learned friend principally relies, where the state had actual possession and control of an asset but no property interest, are in fact irrelevant to the issues before your lordship, other than an interesting discussion about what is meant by concepts of control, possession in the context of this. But in terms of what's relevant to this case, we are not in that circumstance. Indeed, we wouldn't be here if we were, because if we were having to seek an order of possession against the Republic for the shares somehow, we'd be in Section 13.2a territory and not Section 13.2b. The third proposition, and again I had thought this was until yesterday not controversial, is that the underlying policy of the Act is to draw a clear distinction between sovereign activities on the one hand and what can be called commercial activities in shorthand on the other. And the whole structure of the Act, in my submission, pivots around that policy. And as part of that policy, as I've already indicated, if Parliament has laid down in my submission that if a state chooses to create an entity, a corporate entity, to engage in commercial activities, which operates under private law, then that juridical status should be respected. And when we say that juridical status should be respected, that means its assets are also treated as being available in private law.
Well, I think that the submission against you is that I think it's acknowledged that that is the position as far as the adjudicative jurisdiction is concerned, but it's suggested that the execution immunity is wider, and indeed in some respects it clearly is wider.
Well, I agree, and I will come to that in a moment. It clearly is wider because of, for example, Section 13.2a.
Well, indeed. But, I mean, so simply pointing to the principles governing adjudicative jurisdiction doesn't necessarily get you home.
Well, I entirely appreciate that, but it will be my submission that in creating Section 14 in the way it has done, structuring the Act, as interpreted in the courts, what is clear is that if that decision is taken by an entity, for both purposes, respect is given to the juridical status of the corporate entity, and that includes its private law right, private assets, law assets. And it doesn't matter whether it's adjudicative or enforcement, and I'll explain that in a moment. And part of the rationale of that is one sees that as the authorities have developed, the courts have been very clear, and Hemisphere is a good example of it, to say it really doesn't matter how much control that the state retains over the separate entity, as long as it is still functioning as a separate entity, even if you've got wide-ranging control, then you give effect to that separate juridical status.
Is this a presumption, a strong presumption, or is it absolute?
No, it's certainly not absolute.
It's not absolute because there must be situations where a separate entity holds state property. So, I mean, basically, this case turns, in your view, on the width of the concept of property, and you would confine it to legal or equitable and say that a mere claim to control can never, is that right, never suffice? Or is it a valid judgment?
Unless it's based on a proprietary right.
Unless it's based on a proprietary right.
Exactly.
I mean, an example might be a state-owned patent made available to an independent defence contractor.
That is exactly, and that's the example I used earlier, very inelegantly. But, my Lord, it goes slightly further than that, because I do say that the fact that you are dealing with a position where the state has deliberately set up an entity to embark upon commercial activities, knowing, and must be taken to know that the consequences it then divests itself of immunity, includes within that the assets of that entity will also be subject to private law. So the strong presumption is that they are divesting themselves of immunity per se. So it is the paradigm example, if one would like, of the state entering the commercial arena. And, my Lord, in relation to the sort of level of control, and that's why I do look at the controls over the entity, your Lordships will remember the pithy summary of Lord Justice Stevenson in Trentex, where he's, having rejected all of the acts amending the Central Bank of Nigeria's status, he said, a hobbled horse is still a horse. And indeed, one is tempted to say in the light of the authorities that it doesn't matter how much the horse has been abused, it doesn't matter how much it's been ridden or misused, if its ears twitch, it eats hay, and its tail flicks, and its heart's beat, it's still a horse. And that broadly is, where, unless the entity has been assimilated back into the state, then it's independent, and it would be the same test if one's applying for the assets. If it's been assimilated back into all purposes, the exclusion of the true owner, the state, one could see that then it becomes state property. That is it. Just turning briefly to my learned friend's explanation of the case, if your Lordship could take up paragraph 102 in our written case, page 45. We identified, I hope fairly, how the appellants put their claim for the Republic's immunity in their written case in 102. And I don't go through that in detail because your Lordships have read it, but I just draw attention for present purposes to 1022 to 1025, which summarise their general political interest and control. And that is what, in essence, because it comes down to the special legal regime, that is what they say is sufficient to make these shares their property for the purposes of section 13(2)(b). While we've got that open, your Lordship also might like to look at paragraphs 2 to 5 of Botash's case, which are on page 2 of their written case. I invite your Lordship to read that rather than me read it out. And then one stands back to think about the consequences of that. And before I do that, can I just show you how the argument will be developed, because they've already developed it. This is Botash's argument in the Court of Appeal. One could take the record at volume 4, please. Tab 45, page 953. At E, and I don't accept for the moment that this is accurate, but the case that they explained and ran in the Court of Appeal in relation to the commercial purposes exception is that the adjudicative provision is narrower than in relation to the enforcement provision. And if one goes forward to page 955, paragraph 135, when dealing with the commercial purpose exception under section 13.4, my friend's submission were that the courts have recognised that an asset may be held for a multitude of purposes. In those circumstances, the claimant, that's Tepe, must show that subject to de minimis exceptions, all of those purposes are commercial in nature. If one non-de minimis purpose amongst the many purposes for which an asset is held cannot be shown to be commercial, then the asset is immune from enforcement. Now, take that back. What my learned friend has done in his formulation of the case is to flip the exception in section 13.4. That says that you, if you have it open, it's tab 1 of the authorities bundle. Page 10. (13.4) was the exception, which we say applies after you determine the question of proprietary interest. And it says that it does not prevent the issue of any process, but only applies to 2B, note, not 2A, of any process in respect of property, which is for the time being in use or intended for use for commercial purposes. My learned friend's submission to your lordships is to flip that round and say, in asking the question about property, you ask the question, is the property, irrespective of ownership, for the time being in use or intended for use for sovereign purposes? And if the answer to that question is yes, it then becomes the property of the state, and then by definition, the exception can't apply, because a purpose, by definition, is a sovereign purpose. So in that piece of magic, we've now taken something where the state has absolutely no proprietary interest at all in something, said it's being used or may be used in the future at some unspecified date for a sovereign purpose. That makes it state property, and then makes it absolutely immune from enforcement. So not only have we returned to an absolute principle of sovereign immunity, we've actually done it wider than it was before, because it now relates to things in which they have absolutely no interest at all, because it can relate, on my learned friend's case, to something in the hands of a private company.
What's the position, I mean, Alcom and Servas were both about bank accounts and garnishee orders, I think. Certainly Alcom was. What is the position if the state employs an agent to perform sovereign functions and the agent uses its own assets, say money from its own bank account, undoubtedly its property and not the state's, against reimbursement? That's a case where a separate entity is using an asset for sovereign purposes, or could be said to be.
On my feet, I would have thought that might come. Might come within section 14.2.
Right.
My Lord, again, this is being flippant. I think it was a different Lord Reed in a different context in relation to my learned friend.
But that would be a case where the assets, you couldn't levy execution on an asset of that kind if it wasn't the state's asset. You couldn't levy execution in support of enforcing a judgment against the state against the bank account of its agent.
That would be right. So in my submission, what my learned friend has done very eloquently is to turn the entire act on its head. And that applies not only to most of the state economic enterprises in Turkey, it applies to just about every state enterprise, because they're all, to some degree or other, and your lordships will have seen it, we all see it in private, some degree or other, subject to the sorts of controls that you want.
So what's the test in your submission? If you don't flip it round, are you looking for an overall judgment as to whether the most important, significant use or intention for use is for commercial purposes, Or, I mean, I think you're saying that if there is use for commercial purposes, then some sovereign purpose can be ignored. But what is the balance?
Yes, that's for, as I said, my submission is that the Act provides you with a series of questions you go through. So the first question is effectively who is being sued. In the present case, it's Botaş.
Yeah.
The second question is Botaş the state for the purposes of the Act? The answer is no. It follows that Botaş cannot have a claim for sovereign immunity. Third question is, in a property case, to inquire whether any other party, including the state, has a proprietary interest in the way I described before, one that's recognised in private law, in the assets of the commercial entity that is Botaş. And the answer here is no, they don't.
Well, your submission essentially is you don't ask the question, the ALCOM question, until you've decided that those three questions have been answered a particular way.
And the reason is because you're only interested in Section 13, in the Section 13.4 case, if you've actually determined that the property that you're trying to enforce against is the property of the state. That is the threshold question. And you then go follow the questions through, which is, if the state doesn't have any proprietary interest, that's not the end of the matter, because you would still have questions about whether, for example, the property was in the possession of the state, and then it would be a question of whether the nature of the proceedings and the relief sought are requiring the state to do something, whether you get an injunction or a...
Well, that's indirect impleader.
And that's 13.2.
It's hard to apply indirect impleader in an enforcement execution context, isn't it?
It is, but you can see how it could arise.
Well, there's a relationship, clearly, because the basis of the whole rule about indirect impleader is that you can't force the state to appear to defend its proprietary interest in whatever the asset is.
Equally, but the consequence would be, if I wanted to recover property, which we say belongs to a third party, which the state is holding, I could get orders against the third party, but I could not get an order against either the state or indeed an order that would in effect compel the state indirectly to deliver up the property to me.
But you couldn't even get an order for a declaration under that wider
That's
principle,
exactly right.
because that would be forcing the state to appear to defend its proprietary interest. Property being the only species of right which a forensic decision can affect, notwithstanding that its owner may not be a party.
Exactly right. I can hopefully take the Lordships briefly to authorities, Belhaj being the first. I put the files in the right place. For these purposes, you have volume 3 of the authority bundle. And I'm obviously very conscious that two of your Lordships gave the judgment in Belhaj. You have it's behind tab 22 at page 764 in the bundle. Therefore, I do not presume to try and tell your Lordships what your Lordships meant, but could I just draw your Lordship's attention, starting with no disrespect to Lord Sumption's judgment at paragraph 181 at page 925.
That's the electronic page.
It is 925.
It is 925.
Yeah, I'm only going to use the bundle pages, my lord.
Yeah. Thank you.
In paragraph 181, my lord set out the preliminary proposition I made that its sovereign immunity is a personal immunity, and at the end of the paragraph on 926, just around C, the basic rule, subject to the exceptions, is the state immunity is a personal immunity from the exercise of jurisdiction which depends upon the identity of the person being sued. And then I commend to your Lordships the the following paragraphs, which are very helpful analysis that I won't read. Paragraph 188927, which is the issue that we were just discussing briefly. The second sentence, it reflects the broader rule that if the relief claimed would directly affect a foreign state's interest in property, it makes no difference whether the action is framed in rem or in personam, and no difference whether it is brought against the state or someone else who is in possession or control of the property. And that was in essence the point my Lord Sumption was making to me in argument a moment ago, with which I agree. And then 931, page 931, paragraph 196. Again, my Lord summarises there the point that my Lord just made to me, that property is unique because it has the potential to directly affect the legal interest of states, notwithstanding that they are not formally parties. And my Lord, my submission rightly says it. One appreciates the nature of the old procedure, the true nature of a claim in rem was a personal action. And then just above B, my Lord continues, none of this reasoning, however, applies in a case where the foreign state has no legal interest to defend, because the court's decision in its absence cannot directly affect its legal interests. And that we say, absolutely right. That's this case. I would not altogether rule out the possibility that litigation between other parties might directly affect interests of a foreign state other than interests in property, but as I have observed, it's not easy to imagine such a case. The appellant's argument is in reality an attempt to transform a personal immunity of states into a broader subject matter immunity, i.e. one which bars the judicial resolution of certain issues, even where they cannot affect the existence or exercise of the state's legal rights. Now, in an enforcement context, that is what my learned friend's argument is trying to do, because he focuses on whether it's being used or may be used at some future unspecified date for sovereign purposes, and says that's good enough. And I note in passing 195, albeit in the context of a different article of the UN Convention, my Lord quite rightly points out that it's not in force, and of course Turkey and the UK are not signatories, and one has to be careful about it. My broad submission on the UN Convention is you're not concerned with the UN Convention, you're concerned with an English statute which purported to embody in English law what it understood to be customary law, and indeed went beyond it, and there's nothing that's been shown to be a principle of customary international law to change the submissions that I am making to your lordships. And in my Lord Mance's judgment, paragraph 14, starting at page 864, again states the simple proposition in paragraph 14 that state immunity is a personal immunity. In paragraph 15, my Lord deals with the classification in the Christina, and I'll come to the Christina later, but the importance about the Christina was, although there were two principles in operation, because there was a personal immunity, once the state was in de facto possession, the court could not inquire into whether or not that possession was lawful, because that would be infringing the personal immunity. So the case actually proceeds on the basis that they have a property interest simply because they're in possession. They can't determine what the nature of that possession is. And I'll show you that passage in due course. It is implicit, however, in the Christina that when Lord Atkin's second situation is the proceedings relate to state property, insofar as the state is put in a position where it must either forego or appear to defend its property interest, that means exactly that. It has to have something that the court could recognise and adjudicate upon. And that's a private law property interest. The paragraph 21, page 866, my Lord, in my submission, rightly explains the Dolphus Meek case, and it's the summary just below G. Because of the bailment issue, in short, the Commission would no longer be entitled to look to the bank as bailees, but would have as owners to establish title by proceedings against Dolphus Mead. So all founded on the legal right that arises out of the bailment relationship. Paragraph 25, my Lord starts to deal with the UN Convention and quite rightly draws attention to the fact that it's not in force. But paragraph 26, in relation, I stress, to Article 6, not Article 19, is now, that the Travaux put it very firmly in the category of the sort of interest in property that we've been talking about, to the extent it's relevant. Then at paragraph 29, the present appeals involve no issues of proprietary or possessory title. All that can be said is that establishing the appellant's liability in tort would involve establishing that the various foreign states, through their officials, were the prime movers in respect of the alleged torts. Unlike the position in Dolphus Mead, that would have no second-order legal consequences for the relationship between the respondents and the foreign states in question or their officials. None of the above domestic or international cases carries the concepts of interest so far as to cover reputational or like disadvantage that could result to foreign states or their officials. There's nothing outside the concept of a proprietary interest in the sense that I have identified. One then goes forward to the policy of the Act. Perhaps I could take your Lordships to paragraph 65 in our case at page 28. We have set out the principle from, I imagine it's called the Chartier, I'm not sure, which my Lord Sumption referred to in Bank If your Lordships thought there was any ambiguity about this, and I say there isn't, because I think it's absolutely crystal clear, but if there is any ambiguity, we have given you the references to the speeches in Hansard which support the submissions that I'm about to make. But in essence, in the Chartier, Sir Robert Fillmore said, no principle of international law, and no decided case, and no dictum of jurists of which I am aware, has gone so far as to authorise a sovereign to assume the character of a trader when it is for his benefit, and when he incurs an obligation to a private subject to throw off, if I may speak, his disguise and appear as a sovereign, claiming for his own benefit and to the injury of a private person for the first time all the attributes of his character. And that is, in essence, what is happening here. And that is absolutely what the Act was designed not to allow. And there are, your Lordship will be very familiar, if one looks with other authorities, if one looks in the authorities bundle volume 2 in E Congresso, tab 12, page 340. Very famous passage in Wilberforce's opinion.
Sorry, page
340, my Lord.
Thank you.
Just above. Mambisa is a state trading enterprise which manages and operates all Cuban state-owned ships. It is not an emanation or department of the Cuban state. It had independent legal existence, and it's not claimed that it would be entitled to state immunity. It is subject, however, to direction and control by the Cuban government, and the magic words begin to appear, which provides all the funds necessary for its operation. I miss a few sentences. State-controlled enterprises with legal personality, ability to trade, and to enter into contracts of private law, though wholly subject to the control of their state, besides that, are a well-known feature of the modern commercial scene. The distinction between them and their governing state may appear artificial, but it's an accepted distinction in the law of England and other states. Quite different considerations apply to a state-controlled enterprise acting on government directions on the one hand and a state exercising functions on the other. This distinction is
and a state exercising sovereign
functions on the other, my apologies. This distinction is crucial in relation to these appeals. And that is the principle we say was enshrined in the Act with Section 14. And if your Lordship goes forward to, please, page 344 in the bundle. The relevant exceptional limitation which has been engrafted upon the principle of immunity of states under the so-called restrictive theory arises from the willingness of states to enter into commercial or other private law transactions with individuals. It appears to have two main foundations. A, it is necessary in the interests of justice to individuals having such transactions with states to allow them to bring such transactions before the courts, quite. B, to require a state to answer a claim based on such transactions does not involve a challenge to or an inquiry into any act of sovereignty or governmental act of the state itself. It is, in accepted phrases, neither a threat to the dignity of that state nor any interference with its sovereign functions. And in my submission, the paradigm example of that is that if a state chooses to set up a commercial entity, a corporate structure, to operate in private law, have subsidiaries, engage in trade, that is the state entering the commercial arena, period. So the cloak of the trader, in the old words, becomes the corporate veil of company law. And if one then goes to the Hemisphere case, which your Lordships have in Volume 3 of the Authorities Bundle, at tab 18, starting at page 645, and this is actually the only, this is obviously a decision of this board on appeal from the Court of Appeal in Jersey, so it's one that is of most direct relevance to Jersey. It is correct that this was involving considerations of whether or not Gekamine was an emanation of the state or a separate entity. But that's, and the reason why there's no reported case, one would venture to suggest, dealing with the situation where a separate entity is the legal and beneficial owner of assets, but the state claims the sort of interest that my learned friends claim, is because the Act doesn't envisage that, doesn't permit it. And what's helpful about Gekamine is that it explains the policy of the Act, I hope, in the way that I have explained it. And the central to the effect of the Act and the policy of Parliament is the question of whether the proceedings concern the separate entity and its assets. It's also relevant, we'll come later to the alternative case, as to the nature of control and what does or does not give rise to a claim to immunity. I'll take the passages slightly out of order. They're all in, obviously, the speech of my Lord Mans, opinion of my Lord Mans. Paragraph 35 first, at page 663. The board found the decision of the United States Supreme Court to be generally instructive, and it was Justice O'Connor, in her notably internationalist reasoning for the majority, that's relied upon. If one turns the page to paragraph 37, Justice O'Connor recalls the danger of deploying loose epithets, and then she described the practice of states to establish separately constituted legal entities to perform various tasks in terms paralleling those used by Lord Wilberforce in the Congresso. Such entities were typically created as a separate juridical entity by an enabling statute, resonance of what my learned friend is saying here, with a board selected by the government, exactly what my learned friend said, run as a distinct economic enterprise with its own primary responsibility for its own finances, and often without the same budgetary and personnel requirements as government agencies. One of the features of this case is that once you're a state economic enterprise, you're actually exempted from the public accounting procedure in Turkey. That's the reason they get set up in that way. And that's Decree Law 233. She continued, the instrumentality's assets and liabilities must be treated as distinct from its sovereign in order to facilitate credit transactions. It seems with respect obvious, but it's both. It's the entity and the assets. And freely ignoring the separate status of government instrumentalities would result in substantial uncertainty over whether an instrumentality's assets would be diverted to satisfy a claim against the sovereign, and might thereby cause third parties to hesitate before extending credit to a government instrumentality without the government's guarantee. The same principle applies if the third party's, separate entity's assets could be the subject of an unforeseen claim to sovereign immunity because the state pops up and says, although we don't own it and have any interest in it at all, actually, they're immune from enforcement. And then the first sentence of paragraph 38, having recognised at page 628 a presumption that a foreign government's determination that its instrumentality is to be accorded a separate legal status, she then examines some circumstances in which the corporate veil might be lifted or the separate status might be disregarded. Now, again, that echoes the presumption that's found. So this is now an internationalist approach to this, and one sees that again in paragraph 42 at page 666. My Lord referred to two South African decisions and quotes with approval after the passage on 667 at B. The single question in this latter context was, in the court's view, whether the circumstances justify piercing or lifting the corporate veil, absent any element of fraud or other improper conduct in the establishment or use of the company or the conduct of its affairs. The court saw no ground for doing so and no other basis for treating the state as owner of the shipping corporation's vessel, which the claimants had arrested. It added that it does not take much imagination to visualize the chaos that would arise from such a blurring of the principles relating to ownership of property in this or any other field. For the reasons already given, the board considers that the current international and domestic statutory approach to immunity is relevant when considering whether an entity is an organ of the state for the purposes of both immunity and also liability and enforcement. And with respect, we agree. But the principles that are underlying it are the obvious ones, that if you enter into trade, you are using your assets in order to get credit, you're using your assets because people make judgments about your liquidity, and the basic principle is those assets are available either to borrow money or if you get into a dispute and owe a debt, they can be enforced against. And as far as possible, we should have certainty, and that's what the Act is trying to introduce. If you set up an entity deliberately to enter into the commercial arena, it's pretty certain you're a commercial entity and not subject to sovereign immunity. And my Lords, if we then go back in the decision to paragraph 6, page 714, page 650. My Lord deals with the Trentex case and the statement from Lord Justice Stevenson that a hobbled horse is still a horse, and that is very evident when one reads this particular case. At paragraph 9, page 651 at H, cites from E Congresso. At 10, international law is further developed and says that the UK Act was aimed at giving broad effect to, though not precisely following the wording of the European Convention. And then one comes to paragraphs 14 and 15. Where my Lord says in terms, perhaps I could just invite your Lordships to read the two paragraphs.
15 and 16.
14 and 15, my Lord. Just not the actual citation from the convention, just the... So it's emphasising that at the heart of this Act is that distinction which my learned friend seeks to play down. 19, paragraph 19 on 657, I'll read from just B. The Royal Court, paragraph 16, and the Court of Appeal wondered in passing whether the reference to the functions in the Trentex test ought necessarily to apply to issues of execution as well as immunity. Their underlying thought was that constitutional and or factual control might alone suffice to make a corporation liable for state debts. The thought that could open the way to almost any state trading corporation becoming liable for its state's debts. This might be welcomed by some, but it would not be consistent with the common law's approach as indicated in the reasoning and by the decision in Trentex and by Lord Wilberforce's statements in E. Congresso, and still less with the approach developed internationally and by the 1978 Act, which are both at pains to recognise the separateness or distinctiveness of state-owned corporations, notwithstanding that they may have been entrusted with public functions, including activities involving the exercise of sovereign authority. That broadly is at the heart of our submission. At the bottom of the page, at H21, record of Mr. Hurst's submission that, in effect, if you establish a company, then normal company law principles apply, and we agree, and that's what the board accepted. And that's 22 as well. But then you come to paragraph 28 and 29, which we've set out in the case, which I'm sure your lordships have read, which is the statement which we certainly place a lot of reliance. In 28, just below D, in the board's opinion, it's now appropriate in both contexts to have regard to the formulation of the more nuanced principles governing immunity in current international and national law. These, as explained in paragraphs 10 to 18 above, express the need for full and appropriate recognition of the existence of separate juridical entities established by states, particularly for trading purposes. They do this even where such entities exercise certain sovereign authority, jure imperi, providing them in return, as already noted, with a special functional immunity if and insofar as they do exercise such sovereign immunity. A similar recognition of their existence and separateness would be expected for the purposes of liability and enforcement, so it's both. And the Lord then went on in 29, an entity's constitution, control and functions remain relevant, but constitutional and factual control and the exercise of sovereign functions do not without more convert a separate entity, and I put in brackets all their assets, into an organ of the state, especially where a separate juridical entity is formed by the state for what are on the face of it commercial or industrial purposes. With its own management and budget, the strong presumption is that its separate corporate status should be respected and that it and the state forming it should not have to bear each other's liabilities. It will, in the board's view, take quite extreme circumstances to displace this presumption. The presumption will be displaced if, in fact, the entity has, despite its juridical personality, no effective separate existence. But for the two to be assimilated generally, an examination of the relevant constitutional arrangements as applied in practice, as well as of the state's control exercised over the entity and of the entity's activities and functions, would have to justify the conclusion that the affairs of the entity and the state were so closely intertwined and confused that the entity could not properly be regarded for any significant purpose as distinct from the state and vice versa. The assets which are subject to waiver and the commercial use exception in section 13.4, protected by state immunity, should be the same as those which the state's liabilities can be enforced. This was rightly recognised by Mr. Fleming J.A. in the Court of Appeal. We agree.
I don't think any of that is disputed by Professor Douglas, is it? Because it's accepted that it was a separate entity. I mean, are you citing this in order to suggest that the same general process of reasoning should apply to the question what is and what is not an asset of the state?
Yes, because the starting point, we say, as I said before, one goes through a process. The first question is always who is being sued? And central to that is it a state or is it a separate entity? If it is a separate entity, as it is here, the presumption is that the separate entity and its assets, strong presumption, are subject to private law. They are not state property. And that gives rise to the exposes the problem with Malone Friends submission, because it's a conscious decision to subject those assets to normal private law principles that gives rise to that presumption. So you go through that process of saying, is it a state entity? Yes. Well, if it is the state entity exercising sovereign authority to bring it within section 14.2? Here, no. Does the state have any other proprietary interest? In the sense I've used it in the assets, which can bring it within 13.2b. Answer no in this case. Is the state being impeded in any way by an order requiring it to do something or refrain from doing something? Answer no. Once you've answered those questions, it's clear that the property is the property of the separate entity. It's not the state.
Basically, it's the idea of separateness is used as an argument for recognising ordinary private law concepts of property here, and not confusing the two by suggesting that interests which, in terms of execution, are not proprietary. In other words, you couldn't execute against control or probably even possession if it was actually somebody else's property, and you were just holding it as a bailee, shouldn't confuse the position that you retain a straightforward functional separation according to, or proprietary separation, once you decided to set up a separate entity.
Unless the separate entity is exercising sovereign...
Unless, of course, it's... Yeah.
And the point, again, your Lordship said quite rightly in that passage, it's a strong presumption, and for the reasons we set out in our case, the Court of Appeal did not misunderstand that. They actually cite the fact it is a strong presumption, but they say on the facts that that is sufficient to dispose of this case because there's nothing to contradict it, and then they go on to consider the case anyway, so there's no misdirection by the Court of Appeal. Your Lordship's had my submissions. I don't know whether it would help very briefly to...
Do say that, just going back on Lord Sumption's point, Section 14.2, a separate entity is immune from the jurisdiction of the Court of the UK if and only if the proceedings relates to anything done by it in the exercise of sovereign authority. That one can interpret, can one wide enough to cover execution situations?
My Lord, yes, and there is, the Taurus case is an example where they relied actually on Lord Gough in Kuwait Air,
yeah.
But one has to be slightly careful because in Kuwait Air, by the time they got to the decision, it was a damages claim. They'd actually given the property back. But in Taurus, it was a third-party debt order.
We know about Taurus.
Yeah.
Yeah.
But isn't it 14.3 that really extends the 14.2 exception into enforcement? Section 14.3 seems to proceed on an assumption, notwithstanding a submission to the jurisdiction, that the separate entity would have been immune because it was doing things in the exercise of sovereign authority, and then Section 13 is applied to it by analogy as if it was a state.
If the state has submitted to the jurisdiction.
Yes, well, I can see
that's the qualification.
And it may be that the draftsman thought, well, it would have to have had if any issue of enforcement of a judgment subsequently arose, but may or may not be a correct assumption.
Yes, but the answer, if it hasn't submitted, it would have absolute immunity anyway.
Yes.
In my submission, 14.2 does cover both, and that's, your Lordship's familiar with Taurus, and...
Well, it's Taurus in the Court of Appeal, is it?
Both. We've got both here.
Yes, I know, but when you say both here, I don't recall dealing with it in the Supreme Court.
No, that's right.
So it's Court of Appeal.
Court of Appeal.
And first instance.
And first instance.
So for present purposes, the reference to something done in the exercise of sovereign authority would have to be a reference to the actual creation of Botaş as a subsidiary, and possibly the Botaş's then creation of subsidiaries or acquisition of subsidiaries in Jersey.
Yes.
Which is presumably why you were relying on Hemisphere, or one of the reasons why.
Yes, my Lord. And if one thinks about the example my Lord was putting to me, the state's proprietary interest in a weapons system software, which has been handed to a defence contractor because they've got their contract. I might use, say, the Death Star example of my learned friend of fighter jets and whatever else, that in that instance, one might well be able to say, in relation to implementing that software, subject to a proprietary interest, then you could have both arising, but the state entity itself would have a claim to sovereign immunity in relation to it actually implementing something which was on behalf of national security. And that may be sufficient to stop a claim against the asset generally, unless you could strip it out, for example. My lords, can we just look briefly at the Act? I don't know how helpful this is, but we say our construction also follows, just as a matter of ordinary statutory construction. Your Lordships, we've set this out in full in the case. But if one starts at section 6 of the Act, which is tab 1 of the Authorities Bundle, number 1, at page 7, this is all concerned, obviously, with the adjudicative jurisdiction in relation to property. But the importance of this is that wherever the concept of an interest in property is used, it is clearly talking about a private law, or a proprietary interest, which is recognisable and enforceable at private law, and it distinguishes between that situation and simple possession and control. So in 6.1, which is dealing with immovable property, it says the state is not immune as respects proceedings relating to any interest of the state in, and then or its possession of or use of immovable property. So different concepts, but interest must mean legal proprietary interest. Any obligation of the state arising out of its interest in, again, must mean legal proprietary interest, or its possession or use. 2, the state is not immune as respects proceedings in relation to any interest of the state in movable or immovable property, but its succession, gift, or bona vacantia, which are only situations where some form of proprietary title is passed through, so it must be dealing with proprietary interests. 3, the fact a state has or claims an interest in any property shall not preclude a court from exercising in respect of any jurisdiction relating to the estates of deceased persons, persons of unsound mind, or to insolvency, the winding up of companies, or administration of trusts. Again, they're all dealing with legal proprietary interests. So interest must relate to a legal proprietary interest of the state. When one gets to 6.4, a court may entertain proceedings against a person other than the state, notwithstanding that the proceedings relate to property, A, which is in the possession or control of a state, or B, in which the state claims an interest. So they're completely different concepts. One is dealing with proprietary interest, the other is dealing with possession and control. And then it goes on to deal with the immunity and the requirement to prove title, in effect, is caught up by the last words of 6.4, or in a case within paragraph B above, if the claim is neither admitted nor supported by prima facie evidence. The state has to produce prima facie evidence that it has a legal proprietary interest.
This would have been the provision relevant, had it been in force, to the case of the Christina, subject to the limitation that the only relief that could have been granted would have been a declaration.
Anticipated my submission. And then, of course, now the Christina, subject to the commercial purposes exception, is enshrined in section 10. And the different concept is introduced, the concept of belonging to a state in the hybrid situation of requisition. But that also has the 2 limbs to it. So one sees belonging to a state used in 10.2a. So a state is not immune as respects an action in rem against a ship belonging to that state, and then also in relation to a claim in connection with such a ship. 3, where an action in rem is brought against a ship belonging to a state for enforcing a claim, so an enforcement claim in connection with another ship belonging to that state. And 4, state is not immune for an action in rem against a cargo belonging to that state. And then 5, in the foregoing provisions, references to a ship or cargo belonging to a state include references to a ship or cargo in its possession or control, or in which it claims an interest. The interest there must be proprietary interest. But that is not used when one comes to section 13. And the reason for that is really quite straightforward in my submission, that if you had a case of simple possession or control without any proprietary interest, you're in section 13.2a. If you're in the case of where you actually have a legal proprietary interest, you're in section 13.2b. But you have to have that interest, and Botaş doesn't. Sorry, the state doesn't in this case. My Lords, that is the end of my primary case. The alternative case is effectively to say that the Court of Appeal got it right, if I'm wrong on my reading, and that somehow the concept of property imports some degree of appreciation of control or interest other than a proprietary interest. The difficulty arises in my submission in relation to a property case is that a normal instance of ownership is to have some form of control. And that's why my learned friend's been able to develop submissions along the lines he has. But it's the normal function of being the owner is you do control the asset.
Well, it's a specific kind of control. It is a direct relationship with the property as opposed to a right to order its owner about.
You have anticipated. And of course, that ultimately is what the requisition cases are about. Because the requisition cases, all of the rights of the owner have been switched to the service of the state. There is active service on behalf of the state. And it doesn't matter for the requisition cases whether it's the state in possession in the sense of having hoofed the master off because he won't accept the order and replace them with their own servant, or whether the vessel is on the high seas and the master says, yes, I accept the order to obey your orders. The point about it is that they are now operating directly under the complete control of the state for a limited period of time, to the exclusion of the real owners. Hopefully I can take that more shortly then. We've already looked, my Lords, at paragraph 102 of our case on pages 44 to 45. Could we just go back to that, please? As I said before, we've attempted to summarise the factors that my learned friend relies on. And what they don't rely on, they don't rely on, is 102.1, their interest simply as the indirect owner. And then 102.2 to 102.5 we've looked at briefly, and I don't go back into, but the key is in 102.6, which is the special legal regime, as they call it. And I will now come to deal with that. 102.7, we emphasise that, which is that my learned friend concedes that the logical consequence of the appellant's arguments is that all shares of overseas subsidiaries of Turkish state enterprises, not any other assets, will be subject to the control and interest of the Republic. Position in relation to other sovereign states would depend, of course, upon their particular legal regimes. Now, there's 2 points about that. One, there is absolutely nothing in my learned friend's submissions or the laws that they rely on which restricts their case to shares in overseas subsidiaries. These are laws of general application. The only one that actually specifically relates to shares is the ability to change the share capital of subsidiaries of state entities. All of the others apply to assets generally. And with respect to my friend, I've heard nothing that explains how their case arrives at focusing only on shares of overseas subsidiaries.
That could only apply to subsidiaries incorporated in the state's territory.
Well, clearly not. In relation to the...
Subsidiaries altering the capital could only really apply, couldn't it, to, in this case, companies incorporated in Turkey?
Well, one would think so, but that's their case is that that applies to a company incorporated in New Jersey. And that's why, but it is, first of all, it's general. The second is that, of course, my learned friend is conceding within this passage that his whole case relies upon his interpretation of this particular statute in the United Kingdom. So he's trying to find a way of using the statutory language to his advantage, but accepting that they may have a different consequence if he went to America or Colombia, because he's saying it depends upon their particular legal regimes, as I understand it. But The consequence of their arguments, as I've already indicated, is not just that it applies to all assets, in theory, it applies to, one would think, almost all assets of any state-owned economic enterprise, certainly where you have some degree of central planning, if they're Chinese corporations or something like that, where there is often a high degree of involvement of the state in the operation of separate entities. And civil servants are very, very often directors and things like that. We will come back to that in a moment. The special legal regime, I'm sure your lordships have this, but it may help if I just show your lordships very briefly how the Royal Court dealt with these provisions, because in my submission it was very helpful and logically laid out, and we effectively adopted. If I can skip through in tab 9 of volume 1 of the record, starting at page 163, the way my lord. The way the Royal Court dealt with it was under the heading 1, starting the evidence concerning the control and/or interest asserted by the Republic. At paragraphs 99 to 164, they analyse the evidence up to page 184. I'll come back to some of those in a moment. Page 185, paragraphs 165 and onwards are their conclusions on the evidence of control and interest. And very helpfully, in paragraphs 166, 167 and 168, they have divided them to deal with, in 166, measures which apply to Botaş, 167, matters affecting the shares, and 168, measures having direct effect on tippage and bill. So they've actually allocated it for your lordships. One then has, in paragraph 169, the start of the question, is control or interest asserted by the Republic and shares sufficient to attract sovereign immunity? 169, very clear conclusion, it is not, and JCA were equally as emphatic about that. They then set out their reasoning, and one comes to, at the very end, paragraphs 179 to 186, which I could perhaps just invite your lordships to read briefly, so one gets a flavour of and the same exercise is done in relation to interest from paragraphs 190 to 198. I don't think I need to invite your lordships to read it at this stage, but effectively it's the same conclusion because they're relying on the same principles.
Is there anything wrong with the use of the phrase day to day?
My Lord, no, because in the sense that they were using control in that case, it really flows from what my Lord Sumption said. In the case of a requisition, what has happened is that there is now a direct relationship between the state and the ship's master. So, for all purposes, the day-to-day operation of the ship is under the direction of the control. So the equivalent of the day-to-day would be if the shares somehow have been reabsorbed back into the state. But it's using it in a context of, in order for the state to get hold of someone else's property and create some kind of proprietary right, in the sense that they must have somehow assumed use and ownership of it to the exclusion of another owner. And in the context of a company, that's clearly going to be where you've actually effectively taken over the complete operation. No, there isn't, in short. The final conclusions are then reached at paragraphs 199, page 195 through to 203. The only point I note is that to the extent my learned friend is still relying on some kind of allegation that the state's interests would be harmed if the assets were sold, the short answer to that is that Botaş has a legal liability to pay its debts in Turkish law, which it has not done. It's also got a liability under its agreement under the ICC to enforce the award. And the short answer is they would avoid any problems if they pay. The Court of Appeal, just so your lordships have it, page 73 in the same bundle, at tab 2, paragraphs 121 and 122, they start to address the question. And then they, from 124 onwards, is their own assessment through to 138, which I don't invite your lordships to read at this stage. But effectively they say we agree with the Royal Court, although the only difference being they look at it directly under section 13.2 rather than under section 6.4. And we agree. We've set out in our written case in page 61 our section I, which relates to the special legal regime. Subject to your lordships, I'll invite the lordships to have a look at some, but not all of these provisions, but obviously we rely on set out in the case. There are some points to note in the sort of more general application. The first is, and I think it was conceded yesterday, but obviously ownership of the shares is a matter of Jersey law. And that was common ground at all stages before the court. I think it is before your lordship. I'll just make it good if your lordships would take up volume 4 of the record, please.
Professor Douglas accepted this.
Very grateful. It's also common ground, was also common ground that Botaş could ignore the requirements in Turkey and dispose of the shares without the consent or approval of any of the ministries and pass valid title under Jersey law to a bona fide purchaser without notice. And the courts have actually found that. It's also important, in my submission, to note that the requirement of consent or approval to, for example, disposition of assets or liquidation under Decree Law 233, which is, does not apply to a court order. Only applies if Botaş wishes to dispose of it. And if you look at page 70 of our written case, paragraphs 148 to 150, that's not the right reference.
Well,
So
isn't it? It cites...
Well, it's in part the right reference. The significance of this, I won't take your lordships to the actual judgments, this was about attachment in Turkish law. When one looks at what was actually an issue, the debate was in the court, maybe it's better to go to about whether or not the assets were public assets, or whether they were, and therefore immune in Turkish law, or whether they were private law assets. So if you go to tab 9, page 157, sorry, paragraph 157, page 180. You can see that there was much common ground between the experts.
So which band are we reading on it?
Sorry, it's in record volume 1, tab 9,
Yeah.
in the RCJ's
Yeah, no, I'm with
judgment,
you.
page 180.
Yeah.
There's much common down between the experts. The relevant law is 2004 on enforcement and bankruptcy. Article 82, of which provides that state properties and properties designated as non-seizable in any special law are immune from attachment. So there is a provision in Turkish domestic law making state property immune from enforcement proceedings. And there was a difference between the experts as to whether that applied to Botaş's assets. And the court found that if one looks at 158, there was an equivalent provision in Decree Law 233, but that was repealed, so it was only the question of whether or not, in 159, the assets of Botaş would be treated as state property in Turkish law. And that's the point at which the experts divided. They, at 163 on page 184, they prefer the views of Tepe's expert, Professor Karaoglu, and in 164 they find that the assets of Botaş, including shares in any subsidiary, would not be immune from attachment by way of enforcement under Turkish law, but they don't find that republic because, of course, the assets here are Jersey assets. And they set out their reasons in the following paragraphs. And the significance of that in our submission is that that means that in Turkish law, everything is not immune, it's not state property, but somehow, on Malone, subject to exactly the same legal regime that my learned friend relies on, but somehow, when we get to Jersey, shares in foreign subsidiaries have converted magically into state property. That's the thrust of their case. And that just doesn't make sense, frankly. There's a third general point, which was a lot of emphasis placed on the Turkish principle of parallelism, which in very simple terms means that if a government authority does something to establish something, then the government authority has to be the one that approves removing it. And I think, again, my learned friend accepted that it can only apply, again, to voluntary dispositions, but you might want to note in volume 5, just so there wasn't any doubt of the record, the only expert to give evidence on this was Botaş's expert. Tab 49 is the transcript of, amongst other things, his evidence. At page 1171, we have at the top of page, internal page 25, Commissioner Burt asking Botaş's expert, "If I may, Dr. I think what is being suggested, because it's understood that your expert opinion is that certain assets of Botaş cannot be executed against by the Turkish courts. But I think what is being put to you is, does the principle of parallelism have anything to do with that? Parallelism would seem to be concerned with who can sell or dispose of or change these subsidiaries, whereas I think what's being put to you is that you would not appear to have anything to do with the question of enforcement against the assets of Botaş. And then Commissioner Burke continues, so they are two completely separate things, or does parallelism, in your opinion, in some way support the point on enforcement? The answer, I assume I now understand the question more. If it's a court decision on the fate of the companies as such here in our case, or attaching the assets of, or executing against the assets of Botaş, is the subject question, this is done by an outside authority, then the execution is, so it's something different, obviously. The principle of parallelism matters if it's Botaş itself deciding on the fate of the action. Yes, of course, whether such an execution would be possible under law or not, that's a whole different matter in question. So in other words, all of the debate that my learned friend relies on about parallelism, and I'll show you the passages, that only applies if Botaş or the state decide to do something. It's not affected, and there's no relevant interest affected by a Jersey court, for example, issuing execution against assets. And we can, that brings me to Decree Law 233, which we have set out in our written case at page 61 and onwards, paragraph 121. Helpful to have that open. The decree law your lordships will find in volume 7 of the record, tab 67 at page 1885. Some points within this, looking at the decree law, tab 67, page 1885, my lord. Article 1, subparagraph 1, this decree law encompasses the state-owned entities and public economic organisations, as well as their institutions, subsidiaries and affiliates. So it's of general application. And it is the foundation for the governance, if one likes, of state-owned economic enterprises. 2, the purpose of this decree law is to regulate, A, the establishment of state-owned entities and public economic organisations, as well as their institutions, subsidiaries and affiliates, and the management thereof, in an autonomous fashion and in accordance with the rules of economics, so it's a private law organisation. B, the operation of state-owned entities in accordance with economic requirements, in pursuance of the principles of efficiency and profitability and in harmony with each other with the national economy so they can assist in building up capital accumulation and thus create more sources of investment. It's a commercial entity. And that's the whole thing is concerned with the establishment of commercial entities to operate as commercial entities. And we see that in Article 2.2. A state-owned entity is a state economic enterprise established to operate in accordance with the principles and rules of trade in the economic sphere, with its entire capital being owned by the state. That is Botaş. Article 4, in case there's any doubt about it, why they can't argue it's not a separate legal entity because they have a separate legal personality. 2, enterprises shall be subject to the provisions of private law except for in relation to the reserve matters, so they've deliberately subjected themselves to private law, including in foreign states when they set up the subsidiaries. And 4, as one would expect, liabilities of enterprises should be limited to their capitals, so the protection that they get is the normal limitation of a company. 5, even though the directors may be directors who are civil servants, as one would expect, 5.2, Board of Directors is the responsible decision-making body that has the highest level of authority. It operates in accordance with normal corporate principles, and of course, in relation to tippage and bill, it's subject to Jersey law, which is the same as UK law. One can then go forward very quickly to 2 provisions of Article 22 is the general provision which enables a state-owned economic enterprise such as Botaş to establish subsidiaries, and then has similar provisions relating to subsidiaries, which my learned friends rely on. One goes then to 38. This was a particular provision that was of interest to the Court of Appeal and the RCJ. Decisions concerning liquidation, assignment, sale and granting of operational rights of enterprises, etc., within the scope shall be taken by the Coordination Council. The importance of that was it does not apply to tippage or bill, because under Article 58.3, which your Lordships have at 1906, the Council of Ministers can be authorised to give permission to set up companies abroad and participate in established companies abroad without being subject to the provisions of this decree law, and to determine the principles and rules in relation with which these matters for each individual organisation. And in this case, they applied that exception, and they deliberately determined that the two subsidiaries should be set up subject to Jersey law, and 233 should not apply.
And what if it had applied?
If it had applied, then my learned friend would have been able to rely on Article 38 as an additional level of control.
Well,
whereas because it was taken out...
Yeah, well, I can see that, but I would imagine you'd be submitting that this sort of provision isn't in point either when one's talking about third-party debt order or execution or anything like that. No. Right.
I won't press any further. But that was why I took your Lordship also to the principle of parallelism, because it doesn't apply to the fact that the subsidiaries were set up with the authority of Council would not preclude a Jersey court from disposing of it. And the reason for emphasising that is one goes back to paragraph 132 in the Royal Court's judgment, on tab 9 of volume 1, at page 172.
Page 172?
172, my lord, yes.
Page. Thank you.
From 132, Botaş's expert was suggesting that Decree Law 233 applied to tippage and bill. 133, the court said, no, we prefer Tepe's expert. And one can see in 2, for example, the fact that it's not subject to Decree Law 233. And then in 134, having made that decision, they say, what is the consequence of this finding? They refer to Article 38 of Decree Law 223, which we've just looked at. Dr. Cal accepts that if tippage and bill are not within the scope of Decree 233, Article 38 has no application. And so far as Decree 233 is concerned, Botaş is at liberty to sell or otherwise transfer the shares without the need for the consent of the Republic. Yeah. And also, it doesn't apply in a court-ordered situation. And if you go forward to paragraph 192 on page 193, what the court then does is, having determined that against Botaş, in paragraph 192, when it's considering their arguments on their interest and control, the second half of the paragraph, they say, for the purposes of the present exercise, we proceed on the basis that these two aspects have also been established in favour of the Republic. So they make the assumption that, contrary to their earlier finding, actually the decree law does apply and parallelism would apply. So they're actually making as favourable assumptions as they possibly can to Botaş and still dismissing the claim. And that was a rather tortuous way of explaining the judgment. It's not immediately apparent when one reads through that.
Mr. Catchpole, I think we'll, just for your guidance, I think, assuming that there's no problem anyone else, we'll rise about 10 minutes early before 1 o'clock and resume 10 minutes before 2 to keep to the timetable.
Could your Lordship, just before I leave, Decree Law 233, the other significance of Article 38 one has at page 62 of our written case. We set out what we have just been through, refer to one of the things that the RCJ relies on is the Minister's statement in relation to Jersey. Can you find me the other Minister's statement? And then 127. The significance is, of course, it means that the Republic could, if they'd wished, have applied provisions which would have given them control over the disposition of the shares, albeit not in an enforcement, and consciously disapplied it, which is inconsistent, one might think, with the sort of level of control that my learned friend is belonging. Paragraph 127. And therefore, if you could just briefly look at my learned friend's case. At page 7, one has to be, with respect, very careful when one reads his case in paragraph 15, which is really the only place that he summarizes the level of control he relies on. Because in B, what my learned friends say is that as a result of this, and due to the operation of the Turkish law of principle of parallelism, a restriction was imposed at the date of incorporation such that the Republic, and only the Republic, has the power to change the ownership of tippage and bill, i.e. to require the shares to be held by someone other, and that's simply incorrect. And C, the corollary of this, and it certainly doesn't apply in an execution case, and C, the corollary of this is that the shares will only be transferred at the Republic's direction and with its consent, and cannot be transferred out of Botash's ownership without that consent. That is also incorrect. Botaş can transfer the shares, and the court can order and direct their execution without infringing any principles of Turkish law, even if they were relevant. Which one might think puts a bit of a hole in their case. I won't take your lordships. The judgments do set out. Lordships, just bear with me. Just to deal with a point that came up in argument yesterday, page 170 of volume 1 of the record, back in the Royal Court's judgment. Very short point, paragraphs 128 and 129 actually just explained, when I think it was my Lord Sumption who was discussing this with my learned friend, the fact that the Republic might have power to give directions in relation to the shares is neither here nor there. When they have to pass a decree law or equivalent law, which is directed to Botaş, Botaş would then have to implement that as a matter of Jersey law. And that's what paragraphs 128 and 129 say. Just briefly as well as to why they established the two subsidiaries in Jersey, if your lordships could very, very quickly take up volume 10 of the record, tab 97, page 2685. This is a parliamentary answer by the Minister of Energy, who's the responsible minister. And one sees at page 2684 that the question that was a written parliamentary question, why had they established Bill in this case, and Turkish Gas, another subsidiary, on Jersey Islands? And over the page, the answer is that the purpose of Botaş is to procure natural gas over prices that are acceptable to our economy and to meet our country's increasing need for natural gas, etc. They stress the international aspects of the business, and then right at the end, last paragraph, on the other hand, the headquarters of Botaş International Limited, Bill, was chosen to be situated on Jersey Islands due to the following reasons: provision of certain tax concessions, and the presence of many companies operating in the international petroleum sector, and it happens that they can use the same law firm that they'd previously used. But the major driver is that they want to take advantage of the tax regime in Jersey. So if that isn't them descending into the international commercial marketplace, it's very difficult to imagine what would be. Could I invite your lordships to look at our written case, page 71. We've, under the heading little a, from 152 onwards, we looked at some of the other measures that the appellants relied on, which apply to Tippechin Bill, and one of them was in relation to the appointment of directors. And if one turns the page, one sees at 154 that Advocate Evans, then appearing for Botaş, conceded that, as he had to, that the directors, even though they are civil servants or ministers, they regulate the day-to-day activities of the company, and that they are acting as directors with obligations to the company. And that's reflected in the Court of Appeal's judgment at 1454.3, as we've set out. And we suggest that that's entirely correct in the light of the authorities, to which I'll come shortly. There's then the law 4046, which, just for your lordship's note, is paragraphs 105 to 111 of the Royal Court's judgment. It's our written case at paragraphs 139, 141. I don't think I need to go into any detail on it. Page 66 of our written case. Again, it's a law of general application. It is a law relating to privatisation. So in other words, it's specifically about not taking back sovereign immunity, but actually selling it into the private sector. And as we said, it was common ground. It only applies to voluntary decisions. I don't think I need to add to anything that we put in there. Parallelism is dealt with in our written case between paragraphs 142 and 145. Again, I don't think, unless there's any question that I need to add to it, I've dealt with the one issue that I had to, that arises out of it. And there was one final issue, which was in relation to Article 28 of Decision 2014-6842, and I'm not sure I even need to go to that, to be honest. So I invite your lordship just to note that in paragraph 184 of the judgment of the Royal Court, again it's a principle of general application, when one actually analyses and sees the level of control that's available, one can't get to a conclusion that they have the sort of level of control that would even be justified if they were right about what the authorities they rely on meant. Because it is entirely general, entirely regulatory, with the normal incidence of state economic enterprises, some involvement in the management, budget, and directors. One then comes into the authorities. Could I take your lordships to paragraph 165 of our written case? Which is page 75. And if your lordships could also turn up at the same time, paragraph 90 of Botash's written case. Page 28. The definition of control urged upon you by, at that stage anyway, my learned friends relied on a judgment in New Zealand in the Solicitor General and Bartlett, which was concerned with the meaning of effective control. And Mr. Justice Stevens considered the question was, did the respondent have the capacity to control, use or dispose or treat of the property as his own? The difficulty in our submission with that submission is if one looks at our case, 165, I can take you to the authority if you'd like, but this is a provision in an act that was designed to confiscate the proceeds of crime. The relevant section of the Act we have quoted is section 29, which is in the judgment, which says the court may treat as property of that person any property that the court is satisfied is subject to the effective control of the person, whether or not the person has any legal or equitable estate or interest in the property, or any right, power or privilege in connection with the property. And that is the section that is concerned with the express power that's given to the court to pierce the corporate veil. So it's the exact opposite of what the Immunity Act is intended to achieve. So one can discount that as a relevant consideration or test to the present circumstances. We then come on to the requisition cases, which we've already touched on in part in the arguments. If I start, before I look at the Christina, could I invite your lordships to look at the France Fenwick case, which your lordships have in the first volume of the appeal, of the authorities bundle. Page, tab 6, page 109.
Sorry, we're going to authorities 1.
Volume 1, tab 6, page 109, my lord.
Thank you.
This was a case concerning the Emergency Powers Act in the United Kingdom, 1920. The importance of it is that it, first of all, gives an explanation of what requisition means, albeit I accept in a statutory context, but also as to when a vessel is requisitioned. There has to be a positive act where it is brought into the service of the state. So, one sees from the head note, by regulations made under the Emergency Powers Act 1920, government was empowered to requisition ships and to prohibit the unloading of ships and take possession of, inter alia, stocks of coal. Compensation is paid, and then during a coal strike in 1921, when the regulations were in force, the suppliant's vessel arrived in the Thames on the April the 2nd with a cargo of coal for certain consignees. On the same day, a customs officer boarded the vessel and, acting on the instructions, told the chief officer that in no circumstances is the vessel to discharge without permission. The vessel accordingly lay with the coal on board till April the 21st, on which date the government requisitioned the coal, and on April the 22nd, the vessel was ordered by a government department to proceed to Erith and discharge there, which she accordingly did, the discharge being completed on April the 23rd. The owners of the vessel effectively argued that the vessel had been requisitioned when they were told in no circumstances should you discharge. So, and they wanted to claim compensation from that date. Over the page held, the word requisition in the regulation meant some effective and positive dominion or control constituted by a definite order given under the regulations, that no such effective positive dominion or control was exercised till the vessel was directed to proceed to Erith and discharge her cargo there, and therefore under the regulations the suppliants were only entitled to compensation in respect of 2 days only, namely April 22nd and 23rd. And the Mr. Justice Wright, as he then was at page 115 in the bundle, sets that out towards the bottom of the page, just about 2/3 of the way down. There's a word in quotes, requisition with a capital R. Requisition so used in para 25 means, in my judgment, some effective and positive dominion or controls constituted by a definite order given under the regulations. Thus, the order to proceed to Erith and discharge constituted such a requisition. The vessel, no doubt, remained in the possession of the suppliants by their master and crew, but she was required to be placed and was placed at the disposal of the department. She was performing the service which the department had ordered, and that is the key to all of these, that an effective requisition is when the vessel is being deployed in the actual service of the state. The position is, in my judgment, different while she's merely prohibited from unloading under paragraph 11.2. She was not then performing any service on the orders of the government. And then he repeats that on page 118, just at the end of the first paragraph on that page, the last sentence. I cannot find it suggested, still less decided in any case, that a mere direction by the government to a ship to go to a place, or a fortiori, a mere negative direction, such as not to unload without permission, can constitute a requisition or a requirement that a vessel should be placed at the government's disposal within such a regulation as the present. And broadly, that is then reflected in the other requisition cases. There are two that, in my submission, your lordships may wish to look at. There's obviously the Christina, and then the Condado, which was the case in Scotland. Both related to the same Spanish decree. They illustrate, in my submission, a number of different things. The first is that mere possession of the property does not of itself create a right in property. This may be obvious. You need something else, no property in or over it. The nature of the proceedings, as my Lord Sumption Velhaj had identified, are critical. In Il Condado, the case where the state was the plaintiff, and it was seeking damages for delay due to the attempt to seize the ship. So it had lost its immunity, even though it was in active possession of the vessel, because it couldn't establish lawful possession. And we'll come on to why. My Lord Sumption was absolutely right. The other distinction between the two cases is that in the El Condado, the vessel was actually docked in Greenock, Scotland, at the time the decree was issued. So it was in British territorial waters. Whereas in the Christina, the vessel was on the high seas en route from the Baltic at the time the requisition was ordered. So there is another explanation for the difference in the two cases, but I'll come on to it. In the original claim in El Condado had been for the equivalent of the claim in the Christina, which was for a claim for possession by the original owners. That failed on basically the same principle in the Christina, that it was an action against the Spanish state as the people in de facto possession, and you can't implead the state. And they said that's what the Christina meant as well. And we'll look at that in a moment. The Christina was different facts, but in my submission, when one reads the judgment, it's basically the same principles, which was you can't implead the state. So if it's a direct, since they were the people in possession and the nature of the proceedings was to recover possession from them, that was directly impleading the state. But secondly, being in de facto possession meant that they had a claim to a property right. But they didn't go into determining, and couldn't go into determining, whether or not that was valid or not, precisely because it was a claim by the state.
I mean, the debate must have turned around the effect of the Spanish legislation rather than the simple matter of de facto possession, because the judges managed to park the question whether the state immunity was absolute or limited, because they disagreed about that. And the way that they were able to park it, as I understand it, was that on any view, the decree of the 27th of June was an exercise of sovereign authority, which was the basis of the right, because it was a ship which was not within UK territorial waters when the decree took effect in relation to the ship. So it must have been critical to look at the nature of that decree and not simply at the fact that the consul happened to have taken a crowbar and broken into the cabin of the master.
Well, I agree. The difficulty is that their lordships express themselves in different ways. But that, I would agree with that analysis.
Well, the problem was that at that stage, the prevailing view in English law, rightly or wrongly, was not the same as the one that underlies the Act. And that was a matter on which their lordships were disagreed. So they decided it on a basis which made their disagreement immaterial.
And it gets worse, because what my learned friend then seeks to do is take the principles out of a case that was not decided under the Act, which was applying a different regime, and tries to say that therefore that's what you use to interpret Section 13(2)(b) alone. And that's just wrong, in my opinion. And I'm not sure how helpful it would be to your lordships to go through the two authorities. If it is helpful, I'm very happy to.
We'll probably have to.
But I will very happily go
I
through.
don't mean necessarily with you, but by ourselves to...
Well, can I just illustrate them, perhaps in the short period before we rise? If one could start with the Republic of Spain and the National Bank of Scotland case, which you have in authorities bundle 1.
Is that the first case?
The first case is in tab 8 of...
Yeah, I mean, the Christina comes first.
The Christina comes first. It's helpful to start with the Scottish one because they explain the Christina.
Right.
At page 160, we've set this out in the case, I don't repeat it, but on page 160 from about halfway down, they've actually set out the terms of the decree that apply to both the Christina and this vessel. And that's why I started with this. And what is clear about it is that it is a law that is requiring possession of the vessel. It wasn't seeking to transfer a property, it was possession, lawful right. But it is the absolute dominion of the state. So the vessels are subject to the requisition decree. They're put into the immediate and complete disposition of the state. Secondly, there has to be a positive step by the ship owners to deliver their administration to the bodies identified by the government. And that body then provides orders in relation to the vessels. And thirdly, the owners, i.e. private persons or company, are expressly prevented from exercising any rights in relation to the vessel during the period of use. So it is just like in Fenwick, the complete deviation of the vessel to the actual service of the state on direct orders from the state under the direct control of the state. And that is not this case. And whatever principle one applies, that is not this case. And if one looks at the judgment in, one goes forward to page 171, actually out of... This is the judgment of the Lord Justice Clerk, halfway down, there's a paragraph starting with Christina. The Christina was simply an instance of the immunity from legal process, which the courts recognise as attaching to an independent sovereign state unless it waives its immunity by actively invoking the jurisdiction of the courts, as when it brings an action, or by passively submitting to the jurisdiction, as when it appears in an action without objection. And where in an action directly or indirectly in pleading a foreign sovereign, the immunity is pleaded, the courts are precluded from embarking upon any inquiry into the matter in dispute. The jurisdiction is excluded. From this, it follows that both in the Christina and in the proceedings in relation to the El Condado, the immunity being pleaded, no question was or could be decided or even discussed as to the validity of the decree of requisition, either within or without Spanish territory. The jurisdiction having been challenged, in neither case can the judgment of the court be pleaded as having affirmed the validity of the Spanish decree or the legality of the requisitions thereunder. And
so it doesn't turn on any view that the Christina was decided as it was because the vessel was on the high seas at the later degree, and indeed I see that they, or Lord Jameson at any rate, at page 421, 167 at the foot, casts considerable scorn on the suggestion that a ship might, for present purposes, fall to be regarded as floating part of the flag state.
exactly. And that was the next, 166 to 167. And then...
Yes.
But it would be a pretty extraordinary reversal of ordinary principles if it were held that a state could not requisition on the high seas its own registered tonnage without it and have it recognised in international law.
But what they did, what His Lordship was saying there was, in both courts, they said that they're going to apply the principle that they will not recognise a confiscatory decree, and because the vessel was in British territorial waters, it did not have effect. Therefore, it was an unlawful possession and couldn't found title to a claim. And if one looks at the bottom of page 167...
And what was critical was that there was actually a claim before the court.
Exactly.
If it had been simply a defence by the state, or it would have been different.
As it had been earlier in the proceedings, when there had been the order of being discharged because the state was in actual possession,
yes.
And when the owners brought the claim, just as in the Christine, the sheriff said, I can't deal with that.
Yeah.
And just to be clear, on 167, I think Lord Sumption, to put his mind at rest, what Lord Jamieson said was that a private ship in a foreign port is fully subject to the local jurisdiction in civil matters. The jurisdiction of a state over those on board its vessels on the high seas has no application to the circumstances of this case. So he wasn't purporting to make any, he's just looking at it, well, it was in Scottish territorial waters and therefore it's subject to Scottish law. And I think that probably, I don't need to go to any other passages. That might be a convenient moment.
We'll resume at 10 to 2 then. Thank you very much indeed.